aspirants. Hope you're all doing well and started preparing for the prelims Civil Judge Examination 2023, which is scheduled to be held on 19th August. And before going into the topic, let me introduce myself. I am Saifullah, advocate, practicing before the Madras High Court for the past 20 years, and I also have been a guest lecturer for more than 7 years, starting from Dr. Ambedkar Government Law College, Chennai, followed by School of Excellence, Faculty of Law, Tharmani, and my last tenure was before SRM University, Faculty of Law. And due to my busy practice schedule, I could not be able to continue the guest lectureship. However, pursuant to the this notification, my students and my learned friends who are in practice, they requested me to give some lectures, in particular touching those syllabus of prelims subjects. And I said them I am having a busy schedule at the professional front. I don't know whether I can able to give the lectures, but however, since they persisted, then I have considered to the request that subject to the availability of my time apart from the practice, whenever I find time, let me give some lectures touching the topic, so that they will also immensely benefit out of it, and which will enable the aspirants to crack this competitive exam. Therefore, I have started this YouTube channel. Now we will go into the topic. Civil judge or judgeship, it requires the candidate a high moral standard, which consists of honesty, integrity, courage, sound mental balance, and common sense, and knowledge of law, and to be efficient, and to in functioning in the administration of justice, more importantly, impartially to the society. I recall when it comes to the integrity, an anecdote which dates back to the Maurya Empire. The emperor of the Maurya Empire, he called his son, the prince, to learn the art of the statecraft from the prime minister. And he said that you go to the prime minister and learn the art of the statecraft. And this prince also, he came to the Magadha city, and he inquired about the residence of the prime minister, and the people said that that gentleman, he lives outskirts of the city in a small thatched hut. And this prince, he went to the residence, and by that time it became late night, and there he saw an old man writing some accounts with the oil lamp. Then after some time, that old man switched off the lamp, and he lit up another lamp and started and continued work and writing. And And after that, he finished the work. He saw this the young prince, and he inquired, "Who are you, and where he is coming from?" And this prince said everything, but he said to the old man, uh, before learning the art of the statecraft, he was puzzled by the act of the old man using the two old lamps, and so he wants a clarification. Therefore, he inquired with the old man why he does so. Uh, the old man, uh, the legendary Chanakya, the author of the monumental work Arthasastra, with his wise and a, a classical statesmanship, he replied to that prince, when you saw the first instance, I was doing the work for the state, and the state provided me the lamp and oil. The lamp belongs to the state, and the oil also belongs to the state, and therefore while I was doing the work of the state, I was using the lamp provided by the state. Once I completed the state work, I shifted to my personal work. Therefore, I switched off the lamp which was provided by the state, and I lit up my personal private lamp for my personal work. This was the response of the Chanakya. The prince, he immediately he responded, "Sir, I came to learn about the art of the statecraft, but you have demonstrated, and I have learned everything about what is the statecraft," and he departed. Therefore, one who becomes a judge, he or she should draw a line between the public life and the private life. Uh, this will come only during the process of one's functioning as a judge, and slowly the judge has to inculcate all these qualities in order to administer the justice without any fear or favor. Having said this, I would share some tips for the aspirants before preparing for this competitive examination. Every student or an aspirant should spend minimum 8 hours a day for preparing of this examination, because the subjects in the prelims syllabus, even though they are limited, but if you go through the barracks, the provisions in the barracks of those law subjects, they are indeed very vast and voluminous. If you take Civil Procedure Code, it runs 158 sections. Particular, there is Order 21, which relates to execution of decrees and orders. It alone adds 106 rules. This particular proviso, Order 21, is the lengthiest chapter in the CPC, and followed by Criminal Procedure Code. It has 483 sections, and you have a Negotiable Instruments Act. It has 148 sections, and Constitution of India, there are 392 articles, and the Indian Contract Act, it has 238 sections, and the Indian Penal Code, it has 511 sections, and the Indian Evidence Act has 167 sections. Therefore, to cover all these sections, it requires substantial amount of time. So it is understandable that the aspirants are engaged in the profession or in some other occupation, but in order to crack this exam, one has to spend quality of a dedicated time. So it is strongly recommended for the aspirants to chalk out a systematic study schedule, uh, which proportionally giving due weightage of these subjects. And I also recommend the aspirants to to read the Hindu newspaper every day, uh, particularly those news coverage which touches the legal issues which happens across the country, and the judgments delivered by the High Court and the Supreme Court, and more importantly, the editorial article in the Hindu, where the eminent jurists and many senior advocates, they write articulate articles touching the legal issues, and sometimes about the Supreme Court judgments. So which will immensely will help the aspirants not only at the prelims level, but more importantly during the viva was, an aspirant who does this practice, he or she would be in a better advantage position at the viva was. Therefore, this is the point one. And secondly, I have come across some aspirants who have stated that they will give a rough attempt without any serious preparation. If at all they clear the prelims, then they will go for a deep study for main examination. I am of the considered opinion that this is a very dangerous idea that aspirant of the civil judge examination would have. Never ever attempt this examination in a casual manner. What happens when you clear the prelims just for a chance? You will not have any sufficient time to prepare for the main examination, and ultimately you will regret, and you will meet a failure, and which has consequential repercussions to prepare again for this examination, and we don't know when the next notification will also come. Therefore, once you have decided to apply for this examination, at the threshold stage itself, one have to make a strong mental makeup that he or she is going to crack this exam and to going to become a civil judge, whatsoever may come across in his or her pursuit. And this is the second point. And the third one is about the reading pattern of this examination, in particular the prelims examination. Most of those aspirants, they would have studied law during their college, and also know something about law, something about law subjects. They would have read across various law subjects, and some law concepts and principles of law they would have in their memory. So each and every aspirant is somehow at an average level of the legal knowledge, but the prelims examination does not concern about what is the knowledge you have. It is primarily, the prelims examination focuses on the conceptual clarity of the legal principles that the subjects in law they mentioned, Uh, so one has to uh, start reading the bare acts between the lines, and also one should always should have a highlighter when reading the bare acts, and to highlight those ingredients of the provisions of law. So there are many textbooks available in the market to support the understanding of the application of law. So, while reading the bare act itself or the textbook, the aspirant has to take notes along the side of the reading. Uh, I will use some illustration so that you will understand how to approach the bare acts and the textbooks, and what methodology of the reading you should employ during the preparation of this examination, in particular the prelims examination. I will give an illustration. This illustration I have took from the recently held Puducherry Civil Judge Examination 2023. In the prelims question paper, they have asked a question touching the Constitution. The question is, right to property is option A, fundamental right; option B, constitutional right; option C, civil right; option D, none of the above. Now, if you focus on the plain language of the question, some students who have not read and understood the depthness of the provisions of law will commit a mistake by choosing right to property as a fundamental right, or some who have some basic knowledge will choose it is a civil right, because legal right is attached to right to property. But those aspirants who have studied the articles of the Constitution threadbare, they will be in a position to pick the appropriate answer. It is a constitutional right, because right to property under Article 19, it was a fundamental right. Subsequent to the 44th Amendment Act, Article 300 capital A was inserted in the Constitution, which seized the right to property from the fundamental right, and it was escalated to the constitutional right. So unless aspirant who have not studied both the proviso, Article 19 and Article 300A, he will not be in a position to choose the right answer with certainty. Then we'll go to the second illustration. This is also I am taking from the same Civil Judge Puducherry prelims question paper. They ask the question from the subject Transfer of Property Act, which is not a transfer of property. This is the question. Option A, sale; option B, mortgage; option C, lease; and option D, pledge. Now, to approach this question, an aspirant should have a well-grounded conceptual understanding of the application of Section 5 of the Transfer Property Act. Section 5, it defines the following ingredients which constitute the transfer. So these are the following modes. Transfer of property occurs: sale, by way of lease, by way of mortgage, by way of gift, exchange. So these are the 5 modes of transfer enumerated under Section 5 of the Transfer Property Act. So where is the pledge is there? Pledge is out of the list. Therefore, the right answer is the pledge. But however, the examiner tactfully and very carefully have employed the word pledge in order to confuse the aspirant to choose a wrong answer. Therefore, one should be very careful and should be very serious while attending the questions, the prelims question paper. Then I will take another illustration, illustration number 3. This is also from the same question paper, prelims Puducherry Civil Judge Exam 2023, and this is about CPC. They asked the question which runs like this: in order that a judgment should operate as res judicata, it should have been rendered by option A, a court of competent jurisdiction to try the subsequent suit; option B, a court of competent jurisdiction to try the earlier suit; option C and D are irrelevant. Let us not go into that. Now, which one is the correct answer? For that, one should have a clarity of section 11, the doctrine of res judicata in Civil Procedure Code. Section 11 clearly states that a judgment will operate as a res judicata of a competent jurisdiction court to try the subsequent suit, not the earlier suit. So already the judgment has been delivered by the competent court. If the parties, they file a suit subsequently to before that court, then section 11 comes into operation, principles of res judicata. This is absolutely a classical example how to approach the reading of the provisions and the principles of law. Having said all these illustrations, I hope that the aspirants, you have got a better clarity how to prepare for this examination. Fourthly, I will give some a reference standard textbooks of those subjects in the prelims syllabus, and I will upload the list of books at the end of this video, so that you will not be in a position to be hurrying in taking the notes. For Civil Procedure Code, author is C.K. Takwani. For the Negotiable Instruments Act, Avatar Singh, and for the Transfer of Property Act, R.K. Sinha, and for the Indian Contract Act, Krishnan Nair, and for the Specific Relief Act, R.K. Bangia, and for the Constitution of India, for the Bar Act, you purchase P.M. Bakshi latest edition, and for the textbook Constitution of India, I would suggest to purchase either D.D. Basu or M.P. Jain. And for the Code of Criminal Procedure, R.V. Kelkar, and for Indian Penal Code, K.D. Gaur, and for the Indian Evidence Act, Batuk Lal, and for the Information Technology Act, I would suggest Maineni, and other for the Bar Acts, for all the subjects, you be cautious to only purchase the latest edition Bar Acts. Don't purchase the earlier one, because the earlier Bar Acts, they will not have the amended provisions in the Act. So therefore, ensure when you are purchasing the Bar Act, it should be the latest edition of that particular law. And these books are highly standard students edition books. It is not so complex or so tough to read, and therefore I hope that this lecture would benefit the aspirants. And let me see uh, in between the my busy practice schedule, if I find time, I will upload the lectures in this YouTube channel. And I wish you all the very best for this examination, to crack this examination, and to become a successful civil judge.